I'm really pleased to be here again to announce or to introduce Marty Carcieri. He's been here a couple times. I think a number of you have heard him speak, and he's usually spoken so far about John Rawls and I'm blanking on the topic of the Citizens United, that's right. And lots of us really enjoyed his talk. He was going to do the second iteration of John Rawls and civil disobedience today, but he's working on a book on the subject that he's going to be talking about today, and asked if he could change, and I typed back to him, I said, Marty, everybody loves you. You can talk about whatever you want. So, and in particular, in my own personal interest, I talk about everything that basically is really hard for people to talk about, and I look for environments where that's okay. And this is one of the subjects. I only know of one topic in my own personal experience that's harder to talk about, and that is adult incest relationships. So we're quite at the pinnacle, I think, to be able to have this conversation. And in particular, well, I'll read exactly what he's going to cover, but it is assisted suicide. It's not just suicide in general, but a particular type of suicide. So physician-assisted suicide, even for the terminally ill, is legal in only 4 U.S. states. Yet there are now proposals in the U.S. and abroad to extend the right to die, i.e. to obtain and consume a reliable dose of barbiturates, even further, to those over 70 years of age and to those whose longtime spouses are near death and who wish to die with them. How would these proposals fare under the principles of justice articulated and defended by John Rawls, the most influential political theorist of our time? Friend of HCSV, Martin Carcieri, will present his amplification of Rawlsian principles to one of the most urgent public policy issues of our time. Martin Carcieri is an associate professor of political science at San Francisco State University, where he teaches courses on constitutional law and political theory. He holds a J.D. and Ph.D. from the University of California and has published 25 journal articles and book chapters. Please join me in welcoming Marty Carcieri.
Okay, how's that? I'll start off slow. Does that sound okay? Yeah. Okay, can everybody hear me? Great, okay. Welcome everybody. Great to see you. It's great to be back with you again, my people, the humanists. I spent a lot of time with the Bay Area humanists. We got a great group up there. In fact, this is all Rawls all weekend for me because I gave them the presentation I gave you last time on John Rawls yesterday. It just kind of worked out that way. So it's good to be here, and I hope you like what I have to offer. Laura already explained that I was going originally today to complete that handout that I gave you last time, the flip side on Rawls and civil disobedience. And if you want, I promise I'll come back and talk about that. But as Laura said, I've just pitched a book to a publisher of my essays on Rawls. And one of the ones that I'm working on is applying Rawls to this question of the right to die. This is a work in progress. I mean, I've worked it up well enough that you see I've got the outline that I provided you, but I'm still ironing out the details. And so I thought, let me see if I can't make this an opportunity to get feedback from a lot of thoughtful people who probably thought about these issues at some point, one way or the other. And Laura said, well, that's great, we can do that, but in 2 minutes or less, I need you to write it up so I can get it over to the, and I was able to do that because it's all, I got it right here. So anyway, I just appreciate you all, and I hope you like what I have to offer. Does everybody have the outline, the handout, the one-page handout that I provided? Okay, good. Because some of this you've seen before. The nice thing about coming here to present this to you is that I think several of you were at the earlier Rawls presentation that I gave, just laying out his basic theory. And so you've got a backdrop. I'll say a little bit about Rawls's principles, but what I'm going to do, like I say, is apply Rawls's principles to one aspect of a very current issue. So I think we're all aware that end-of-life issues are becoming more urgent by the day. There's pressure for legal reform on all sides. And on the one hand, there has been some progress. There has been some movement. As Laura mentioned, physician-assisted suicide is protected in 4 U.S. states, Oregon and Washington, enacted it by state ballot initiative, citizens ballot initiative. Vermont, last year, enacted it by legislation. The state legislature did it. And then in Montana, it's been protected as a defense by the Montana Supreme Court interpreting the privacy provision of the state constitution. Okay, so 4 states, one way or the other, protect these, the right of physician-assisted suicide. Under these laws, those who are within 6 months of death, as certified by 2 doctors, may acquire and consume a lethal dose of barbiturates, usually either Seconal or pentobarbital. But they have to make 2 different requests for this, 2 weeks apart, to make sure this is not a whim, that they, have thought about this carefully. And again, they have to make this request, and they have to have a discussion with the doctor to try to ensure that the person is mentally competent, that there's no undue coercion, for example, from family members, and that the decision is fully informed. So on the one hand, there has been some progress in this area. But on the other hand, I think you can tell that the progress has been modest. Once again, even in the 4 states out of 50, only 4 states out of 50 have physician-assisted suicide laws. Once again, it can be invoked only where the person requesting it has been confirmed to be terminal and within 6 months of death by 2 doctors. So I'm going to say that although there's been progress, we seem years away from enacting the kind of reforms that are now under discussion in the U.S. and abroad. And 2 in particular stand out, although I've recently determined that for purposes of this book, since this subject is so vast, I'm just going to focus on one of these proposals. But 2 that really caught my eye recently are the following. One is a proposal to allow those whose longtime spouses are near death to accompany them by committing suicide at the time that the spouse dies. So we're talking about the option of a longtime spouse who himself or herself is not terminal but wants to die at the same time as that person's long-term spouse. Very interesting. I'm going to put that one aside. It's interesting, but that really presents a different range of issues than the second one, which is simpler and more direct, and I'm going to focus on that. And that is quite simply, and this is a proposal in the Netherlands, may not surprise you, they are rather progressive there. It's quite simply to allow all those who are 70 years of age or older to end their lives. Now, whether an individual would choose to do this in the first instance is up to him or her. And I'm not going to speak to that. That's an important, compelling issue of morality, of ethics, and the rest of it, but that's not where I'm focused. I'm saying that what this law that I'm talking about, this proposal to allow all those 70 years or older to purchase and consume a lethal dose, whether or not they're terminally ill, upon, to request to die and so forth, to make sure, to ensure that the state's interests in making sure that people don't lightly do this are protected. So I'm going to focus on that one. Let me be clear that what I'm moving toward here is a right, not a duty. In no sense are we talking about a duty to die. I'm going to circle back to this at the end. That would be unconstitutional anyway, for government to simply pass a law saying you now have a duty to die. All right. Now, it's interesting. It's interesting to talk about this to different people because I'm reminded of things that I hadn't thought about and the way that people will come at it and the issues that they'll have. Before I even get into it, let me say that some people, understandably, have said to me, look, you don't need a legal right to commit suicide. You can just do it. Well, I'm afraid it's not quite that simple. A lot of you may know that although there are literally 1 million suicide attempts in this country a year, many of them are botched. Oftentimes people don't know how to do it, or they'll bail out halfway, or they just, and so either with pills or with a gun. And I don't want to elaborate too much because I know this is a hard subject, but it is one that I think our society has to confront as we go forward. So, and in addition to that, in addition to the fact that a lot of suicides are botched, quite simply, the technology exists, and it has existed for a long time, for individuals to consume something that puts them to sleep and they never wake up. This is 100% guaranteed. Doctors have confirmed this. If it's rightly done, if the mixture of approximately the potency of about 50 pentobarbital or Seconal pills put into a mixture and swallowed, you or I would go to sleep and never wake up. This technology exists. So I'm going to say that we're not in a position, I think, where we must simply leave people who want to end their lives and can't get the legal right to do it to just go jump off a cliff or get a gun. Where I'm coming from, and I think where Rawlsian agents would come from, is that a compassionate, humane society would not put people to that, in that position. But again, we're only talking about for those 70 years or older. I'm willing to say that no, a 21-year-old should not have this right. And I can come back and talk about that later. The 21-year-old comes along and says, well, you're giving a 70-year-old this right. Why not me? I'm going to say, because you don't know who you are yet. With all due respect, you're only 21 years old. We as a society have an interest in encouraging, you can go jump off a cliff, nobody can stop you from doing that, but we as a society have a sufficient interest in you trying to find your way, trying to find something meaningful to do with your life, that we're not going to cooperate with you ending it now. Once you're 70 years old, perhaps you're done with your working life, perhaps you're not, but once you're 70, we think that's going to be a different story. But I want to emphasize throughout that this would be a balanced approach. And what I'm really asking us to think about here would be a state ballot initiative that would simply extend this right to those 70 years or older. So again, we already know that Oregon and Washington have already done this for the terminally ill by state ballot initiative. In Oregon and Washington, those who are confirmed by 2 doctors to be within 6 months of death can purchase and consume a reliable lethal dose. They consume it, they go to sleep, they never wake up. So what I'm asking us to think about here is, how would, from a Rawlsian point of view, with Rawlsian principles, how would voters come at and think about and approach a proposal like that? You have the right to vote now on whether, under state law, those 70 years or older, terminally ill or not, have the right to purchase and consume a lethal dose, again, subject to reasonable procedures designed to protect the legitimate interests of the state in preventing suicide, in preserving human life, and so forth. And I'll talk a little bit about those in a little bit. Okay, and again, bear with me. I know this is going to be a little bit choppy, but I'm still working this out, and I appreciate the chance to share this with you. So again, there are calls for dialogue on this. There's calls for reform on this issue, and so it seems worthwhile, even urgent, to examine whether the current state of the law, that is to say, a prohibition on the right to do this, is justified. Let me stop for a second. Sometimes the response that I get from people on this is, government shouldn't be involved in this. It's up to the individual. Okay. My response is, government is already involved with this. We're not in that world that you're talking about. You and I do not have the right, even if we're 70 years old, simply to purchase and consume a reliable lethal dose. There may be some medical doctors here. Medical doctors right now, under the law, have a very strong incentive not to write a prescription for 50-seconal pills for somebody who's simply reached a certain age. Doctors can get in a lot of trouble for that. So government is already involved. This legal right does not exist. The right to physician-assisted suicide for the terminally ill exists in 4 states, but in no state does the proposed extension of the right to those 70 years or older, nowhere does that exist. So I'm asking us to think about that, since this is coming at us. I think that these end-of-life issues are going to become more and more urgent, and it's practically cliche at this point to say that Americans, and maybe this is true of people generally, I'm not sure, we don't deal with death as well as we might. Yeah, I see a lot of looks of recognition here. We don't. Our culture, I think, does not grapple as honestly and thoroughly with questions of death as we might, but I think that these issues are going to become more urgent in coming years. Okay. I hope this was not billed as a comedy show. All right. I should note, before I get into it, that in thinking about this, I'm processing this in my head, trying to pull it all together, I think Rawlsian agents, Rawlsian decision makers would look at this situation holistically. And if they could come at the problem in a comprehensive way, they wouldn't just zero in on something like whether those 70 years or older have the right to do this. I think that they would couple this right to die with universal health care. I think you can get single payer out of Rawls, never mind Obamacare. I think that they would provide adequate funding for suicide hotlines, to support our interest in trying to talk people out in general of committing suicide, especially if they're younger than 70. So my point is that I think Rawlsian decision makers, if they could start the world anew, would come at this issue in a very holistic way. And they would perhaps recognize this right to die under law, but they would provide, again, universal health care. They would provide people the means, I think, to the extent possible, to not be in a position where they're thinking about ending their lives before their productive life is really over. Okay. And again, a state ballot initiative seems an appropriate way to come at this. The federal government's not going to do anything about this, and it's not clear that it should. This really is an issue for the state level, I think, under our system. Let states experiment. That's that federalism, right? The division of authority between the national and state levels of government. So, and again, we've seen examples of this with the Oregon and Washington physician-assisted suicide initiatives. There have been other initiatives like California's Proposition 209, which made state, racial non-discrimination the actual policy of state law. It extended liberty and equality in that sense. Okay, so I want to try to situate that in terms of the type of law, the source of law that we're talking about. The question I'm asking is, how would Rawlsian decision makers, specifically Rawlsian voters at the state level, informed by Rawlsian perspective, how would they approach this state ballot initiative that would extend the right to purchase and consume a reliable lethal dose to all of those over 70? How would they come at this? How would they approach this? Okay, so that's my introduction. Roman numeral 2 under Rawls and the right to die. First of all, let me say that my sources for Rawls' theory, what I'm looking for, what I'm working from, are some sources that, if you were here last time, you know what I'm talking about. Rawls' great book, A Theory of Justice, in which he revolutionized American political theory back in 1971. Political Liberalism, he published 20 years later, as well as Justice and Fairness, a Restatement. He published just a year before his death in 2001. So those are the main books that I'm using to draw his theory from. But in addition, it's interesting to note, you see, I referenced what's called the Philosopher's Brief in Glucksberg and Vacco. Let me tell you about that. Glucksberg v. Washington and Vacco v. Quill were two consolidated landmark U.S. Supreme Court decisions that were handed down in 1997. Some of you may remember these cases. In both of these cases, the question was whether state laws that ban physician-assisted suicide violate the 14th Amendment. The 14th Amendment provides no state shall deny any person life, liberty, or property without due process of law, and also it came up under equal protection. No state shall deny any person equal protection of the laws. The bottom line is that the U.S. Supreme Court unanimously held that states that ban physician-assisted suicide do not violate the 14th Amendment to the U.S. Constitution. They have the authority to do that. They can make this choice as they see fit. So what the Supreme Court did in these two cases was basically kick the issue back to the states. It said, this is not a federal constitutional issue. This is a matter for state policy processes. You folks at the state level should sort this out. And by the way, the fact that your state currently decides not to protect physician-assisted suicide does not violate the Constitution, does not violate the 14th Amendment. Okay? So Rawls was one of 6 major big-shot philosophers like Ronald Dworkin and a few other people who submitted an amicus curiae brief, a friend of the court brief, in these landmark cases of Glucksberg and Vacco. So I'm using that philosopher's brief, it's only about 10 pages long, and it's on the web, it can be found, as a source for Rawls's views. Now, again, that brief was addressing the whole constitutional dimension of the right to die, which is not what I'm talking about. I'm talking about as a policy matter. At the state level, should we enact this into law? Nonetheless, it does touch upon a number of the issues that come up in our discussion, and so I'm using that philosopher's brief as one of my sources, one of my authoritative sources for Rawls on this issue. Okay, now, hopefully a number of you were here the last time I came, and so I don't have to say too much about Rawls's basic approach. Rawls, in revolutionizing modern American political theory, he kind of updated, dusted off, and refined the idea of the social contract. The social contract is a foundation for a society. The idea that the only way we're going to have a society that you and I want to live in is if we think about it like a contract, two-way street, reciprocity, right? You have rights, I have rights, but you have responsibilities and I have responsibilities. Social contract. And this goes back to the great thinkers John Locke, Thomas Hobbes, Immanuel Kant, Jean-Jacques Rousseau. Got this off the ground, and Rawls updated it, this idea of the social contract, and he asked the question that you saw last time. The question that Rawls poses is the following. He says, what would rational, self-interested individuals, equally situated behind a veil of ignorance about the details of their own lives, agree to as the basic principles by which they will be governed forever once they know who they're going to be and why? So again, I walked you through all that last time. That's his question, and his answer is these two principles. And the one that I'm going to focus on, first of all, that I'm going to get the most mileage from, is the first one, the equal basic liberty principle. Rawls says this is the most fundamental principle you and I, behind a veil of ignorance, would agree to. If you and I don't know who we're going to be, but we know we're going to show up as someone, but we don't know who, we want to select principles for our constitutional order that will protect us no matter who we are. And so you remember the equal liberty principle does that. You and I would agree to the principle that each person is to have an equal right to the most extensive system of equal basic liberties compatible with a similar system of liberty for all. So that's the equal liberty principle. And the basic idea is that liberty is the rule, not the exception. We protect liberty to the extent possible, compatible with a like system for others. Okay? Civil society, especially a kind of a modern liberal democratic society, has as its highest goal liberty. At the same time, everybody recognizes that liberty is not license. You and I do not have the right to do whatever we want, right? You and I are free. We have a lot of liberty, but as the old saying goes, my freedom to swing my fist ends where your face begins, right? You and I can exercise liberty up to the point that it starts to really inflict harm on other people. And so that's really what's captured here, right? The basic rule is that each person shall have a right to the most extensive system of equal basic liberties compatible with the like system for others. So that's where we start. That's, he says, you recall the first basic principle we would agree to. And the second principle manages inequalities, and it includes both the fair equality of opportunity and difference principle. So that's that second principle there. So this is the foundation of Rawls' theory. And again, I think a lot of you remember this from last time. So let me take you right, if I were going to drop dead in 2 minutes, I'd want to make sure that I said this next thing, okay? And that is that it seems to me that the most important conclusion I come up with, although this is simply a first step to the rest of the analysis, is at the bottom of your first page. So my two core related theses that I am defending in all of this are the following. They work together. First of all, the autonomy, the liberty at stake in and protected by the recent proposals, and especially 70 years and older. The autonomy of 70-year-olds, the freedom that they would exercise under that law, is among Rawls' equal basic liberties. So you can see that that's the first question we have to have, right? Would the autonomy that would be protected by this proposal to allow those 70 years or older to purchase and consume a reliable lethal dose, would that autonomy be among the equal basic liberties that we've all agreed to under a Rawlsian scheme? And my answer is, not surprisingly, yes, it would be. And here I'm talking about two aspects of autonomy. It's a great word, by the way, autonomy. Auto means self. Nom, like nomos, means law. Autonomy means you make laws for yourself. You are the lawgiver for yourself. All right, so that's an aspect of liberty. So I'm here to say that from a Rawlsian approach, the autonomy that would be at stake and protected by this proposed law for 70-year-olds and older is among Rawls' equal basic liberties. And there's two aspects of this autonomy in particular that I think you can get from Rawls, and I indicate them there. The first one, the first slice of autonomy, the first dimension of autonomy is control over the timing and manner of one's death. And this has been articulated. This is not original with me by any stretch. This aspect of autonomy has been articulated and defended by a number of people, and it was in fact referenced in the philosopher's brief in the Glucksberg and Vacco cases. So right there, I don't think it's too hard for me to show that from a Rawlsian point of view, that autonomy in the sense of control over the timing and circumstances of one's death, would be among Rawls's equal basic liberties. So we're already moving in that direction. The other aspect of autonomy is one that I have defended at length in another article that I published, bodily autonomy. Bodily autonomy, by which I mean the following. Bodily autonomy would be simply control over the contents and boundaries of our body. Presumptively, you and I have the right to control what is inside our bodies. And we're going to see that that's reflected in an awful lot of our constitutional law. The law of abortion. A woman doesn't have an absolute right to get an abortion under the Constitution. Her right is time, place, and manner limited, and yet she has a presumptive right until the point of viability to expel a human fetus from her body. She has control over what shall be inside her body. Okay, so that's the second aspect of autonomy. So this is how I'm coming at it. Once again, my point so far is that the autonomy, the types of autonomy that would be at stake and protected by this proposal to allow all those 70 years or older to purchase and consume a lethal dose would be among Rawls' equal basic liberties, those strains of autonomy. Okay, building on that, secondly, at the very bottom of the first page, I say that Rawlsian voters would thus bring both reflective equilibrium, that is, they would think about this carefully. It's a term that Rawls develops at some length, reflective equilibrium. You think about an issue from many angles over time. It's not just a snap judgment or a whim. Rawlsian voters would thus bring both reflective equilibrium and strict scrutiny. Key constitutional term, I'll come back to that. A term from constitutional law. Rawlsian voters would bring reflective equilibrium and strict scrutiny to bear upon the current legal prohibition on these forms of autonomy in deciding whether to enact the recent proposal into state law by citizens' ballot initiative. So, do you see my point there is I haven't told you yet. I have not nearly concluded what it is that Rawlsian voters would do. Whether they would vote on this or not, I want to try to be as clear as I can here. What I'm saying, my pivotal premise, and if I have anything original to offer here, it would be that Rawlsian voters approaching this question would engage a presumption of liberty. They would look skeptically and with scrutiny at the current legal prohibition on this right. In deciding whether or not to expand the legal right to die to those 70 years and older, they would bring a presumption of liberty. And therefore, the current prohibition on this right would be one that they would be very suspicious of. That's the stance that they're going to bring. That's the frame of mind that they're going to bring to what I'm going to look at on the other side, the standard objections to allowing the right to die. Okay? Any questions so far about that? That is my pivotal premise, and I think if I can make that as clear as possible, the rest of this should make sense. My main point here is the following. I have not told you yet. I have not made my argument yet. How it is Rawlsian voters thinking about this would decide. I still have to make that case. What I'm saying is that given the equal liberty principle and the presumption of liberty that embodies that we would all agree to, under those circumstances, the presumption of liberty, Rawlsian voters would be very skeptical about the current prohibition on the right of 70-year-olds to purchase and consume a reliable lethal dose. Yes, go ahead, quick question. Is my premise so far clear? That's the main thing I want to find out.
Yeah, I think everybody here gets what your premise is, and I don't think anybody here would disagree with your position on assisted suicide for the terminally ill. But when it comes to, say, anybody over 70 has the right to die, it makes me think that there would have to be a very high standard, to prevent fraud and abuse, because...
Well, I'm going to come to that.
Okay. I wouldn't want to have the same standard as, somebody who's been certified that they're 6 months from dying and they're terminal.
Sure.
Because, I could see right to die as being the Republicans' version of Social Security, and then,
okay.
The people who,
so my premise so far is clear?
Who could be pressured, older people who might have diminished mental capacity, who might be pressured, I'm
going to come to that.
Okay,
yes.
That's my concern.
I just want to make sure my premise so far was clear.
I understand your premise.
Is my premise so far clear, folks? That's all I'm asking about. Okay, let me take up, because you're going to have a lot of good questions. Let me take those up on the other side. There are several standard arguments, or opinions anyway, why it is that we should not allow the right to die. And these apply as well to physician-assisted suicide. There are a lot of people who think we shouldn't even allow that. So if you flip over your sheet, what I'm now going to do is take that presumption of liberty, right, that strict scrutiny that Rawlsian voters are going to bring to the current prohibition, and they're going to evaluate the standard reasons, some of which have already been mentioned, why people often argue that no, the right to die should not be protected by law. So the first one is religious and related objections. And again, you can fill in the blanks here, right? The idea that, no. Life, human life, is a gift from God. You and I have no authority to end it before God takes us. You've heard this before. And I'm not here to badmouth people who are religious, but from a Rawlsian point of view, that simply has no traction. You don't even have to go to Rawls for this, right? The Establishment Clause of the First Amendment takes religious arguments in favor of public policy off the table. Even rabid conservatives who think that there should be no abortion rights whatsoever, when they introduce bills to restrict abortion rights in state legislatures, they do not defend these laws based on religion. They know they'll immediately get bounced out of court because of Establishment Clause considerations, right? Congress shall make no law respecting an establishment of religion. So even before we get to Rawls, the Establishment Clause of the First Amendment of our Constitution forestalls this idea that, no, there can be no legal right to die because it's against God's will. Okay. I don't think I have to take a lot of time to convince humanists of this, so I'm gonna move on. And that's, by the way, from a Rawlsian point of view, public reason is an important concept that he developed later in his work. And it's simply the idea that you and I, as legislators or as citizens, when we are giving each other reasons why we should or should not support certain laws and public policies, we have to stick to public reasons. That is to say, political reasons. Reasons that we can expect each other in our capacity as citizens to accept. The problem with religious arguments or claims is that you and I may not have the same religion. And you're sure that your religion says God says this or God thinks that. Well, I respect you as a citizen, but I don't share your religion, so you cannot reasonably expect me to accept that as a reason for infringing on my liberty, you see? Okay, so that's public reason. A variation on this is what are called virtue-based objections. One line of argument that people sometimes I've seen right, and I haven't said to me so much, but will argue is that, no, it's inconsistent with virtue to end your life. You should just, buck up. You should just push on and exercise some virtue. And maybe you've heard that argument before, right? You should live as long as you can because that's the only possible definition of virtue. As I'm going to fill this out, I'm going to suggest that by no stretch do those who oppose the right to die have the market cornered on virtue. Virtue, a good human life. I can easily imagine somebody well advanced in years who the aches and pains are coming and they're not in a hospital yet, but they don't want to wind up spending their last years in a hospital. Maybe they've got a little bit of money left that they want to leave to the local ASPCA or some nephew who's trying to pay off some student loans. To me, that is easily compatible with virtue. So the idea that anybody who would want to end his life before the bitter end lacks virtue, I think, has no traction. And I include that here because that's kind of related to religious-based objections. Okay, the big one is the second one, I think. Preservation of human life and the prevention of suicide. In the Glucksberg and Vacco cases, Chief Justice Rehnquist, who wrote that opinion for a unanimous court, accepted the state's claim that the state has an unqualified interest in preserving human life. Let me let that sink in for a second. Can you imagine? Does that sound right to you? The state has an unqualified interest in the protection of human life. And Rehnquist was a brilliant man. He was a little more conservative than I am, but boy, But I'm willing to say, to be reasonable here, that of course the state has some level of interest in preserving human life, right? And we can look at that in many different dimensions, but certainly the state's got something there. The question is whether it's an absolute interest, an unqualified interest, and you can probably already tell I don't think that it is. And my basic response to that is, again, from a Rawlsian point of view, as a basis for a flat prohibition on the right of 70-year-olds to do this, these ideas that the state has a compelling interest in preserving human life and preventing suicide, those arguments are inconsistent with Rawls's equal basic liberty principle. And I include the key part of it there, right? As a basis for a flat prohibition, the state's claims that it must preserve life and prevent suicide is inconsistent with the Rawlsian principle that we protect the most extensive system of equal basic liberties compatible with a similar system of liberty for all. Quite simply, if the law extends me the right to end my life after I'm the age of 70, by doing that, I'm not interfering with your liberty. This is a liberty that is consistent with other people's liberty. Somebody might say to me at this point, but wait a minute. What about that nephew you've got who really admires you and who would have a hole in his life if you were to end your life? Okay, fair point. But whose life is it? His or mine? Here's the idea. From a Rawlsian point of view, if I'm not trying to deprive my nephew of his right to end his life under the law when he's allowed to, he has no right to tell me when I can end my life. You see that? Contract, mutual advantage, reciprocity. So from a Rawlsian point of view, this idea of an unqualified state interest in preserving human life and preventing suicide is an overstatement and really can't stand on its own. And I want to say, again, I said at the outset, I think if Rawlsian decision makers were constructing the world anew, right, to deal with the problems we have in the society, I think they do things like provide a lot more funding for suicide hotlines. All good, you know? If people are out there who are thinking about ending their lives, who maybe could benefit and find a way to go forward by talking to somebody, by having somebody there to talk to, I think that would be a great thing, and I think Rawlsian voters would support that. But an unqualified interest in preserving human life, not from a Rawlsian point of view. The other way that I come at this, by the way, is the current law of abortion. And as you might imagine, I get an awful lot of mileage out of this. The current law of abortion, once again, basically is that since Roe versus Wade in 1973, and as developed in other cases since then, women have a presumptive right, a time, place, manner, limited right to obtain an abortion. Once the fetus is viable, that is to say, can live outside of the woman's body, at that point, states can criminalize abortion. They don't have to, but they can under our constitutional law. So there's a lot to be said about this, but here's the crux. Here's the crux from my point of view in terms of consistency. If a 21-year-old woman has the right under our law, as she does, to expel a human fetus from her body, having only had to think about it for about a day or two, because states can require that she, a 24-hour waiting period. But if a 21-year-old woman has the right to expel a human fetus from her body, it's not a legal person, but there's human DNA there, then on what basis can we possibly say that a person of mature years does not have the right upon reflection to end his own life? That's the crux of it. That right of the 21-year-old woman is in the law for very good reason. She has a presumptive right to end the life of that human fetus inside of her. Okay, fine, I have no problem with that. That's what the law is. But if she has that right, how can somebody who's 70 years old, of mature years, who has thought about this at some length, not opt to end his own life? The inconsistency between those two, states of the law, it seems to me, would violate equal basic liberty. There's a lot more to be said about abortion, but that's the crux of it, and so let me move on. The next thing, and the gentleman in the back really brought this up, and it's an important point that a lot of people bring up, protecting the vulnerable. And at the outset, I do not dispute at all that the state in banning, the extension of the right to die, has an interest in protecting vulnerable populations, maybe the very elderly who are physically unable to, who would be subject to undue coercion from their family. This is an issue it's a big issue. It's a legitimate concern. And the thing is, as I already pointed out, the kind of procedures that are already in place in Oregon and Washington, right? The requirement that you have to talk to a couple of doctors, you have to request this a couple different times, and the doctor talks to you to try to ascertain whether you're mentally competent, whether you're being unduly coerced, whether you're fully informed about all your options. It seems to me that having those procedures in place for the 70 years old and older would go a long way towards securing the state's interests. Now, it might be objected that even with those procedures, a few people still might slip through the cracks, right? And there might be some vulnerable people who really, under the right circumstances, would not have opted to end their lives quite so early. And my basic response is going to be, don't let what is that phrase? Don't let the good be the enemy of the perfect. Don't let the perfect be the enemy of the good. In other words, are we really going to shut down this right for everybody simply because there might be a few people who fall through the cracks? That's really what it comes down to. Are we going to shut down this right for everybody, including all the people who would exercise it upon due reflection, who are not being coerced? Are we going to shut it down for everybody because a few people might fall through the cracks? I don't think that's a balanced approach. I think that you put the procedures in place. You require somebody who's 70 years or older, if he wants to exercise this right, to talk to a couple of people. They don't even necessarily have to be medical doctors. Could even be a lawyer, could be a philosopher, could be somebody who's going to be there to listen, to talk to them and say, look, you've got your right, I'm going to write, approve this for you and you'll get to do this. But talk to me first. Is this something that you really want to do, Have you thought about the impact on your family members, You have the right to do this, but we collectively, society, through the state, are going to require that we have this conversation first. At the end of the day, you'll have your right to get your lethal dose, but since we collectively care to a great degree about your well-being and we want to make sure that you do opt for life if you see a way to go forward, talk to us. It seems to me that those kinds of procedures in this quite imperfect human world that we've got would be good enough. But I'm interested to hear feedback on that. I don't see that as a deal breaker. That's my point. I don't see that as a deal breaker. And even though this regime would not be perfect, again, from a Rawlsian point of view, we expand liberty where we can. As long as that liberty does not materially harm other people, we expand liberty where we can. Okay. The other thing about that, about protecting the vulnerable, is let me point out, the difference principle. That is the second part of that second principle, second basic principle over on the other side, that inequality, this is the difference principle. Any inequalities in society are to be to the greatest advantage of the least advantaged members of society. That takes a long time to unpack. I'm sure I don't completely understand it. Maybe Rawls himself didn't. But the idea is that if you wind up among the least advantaged in society, the basic rules are such that we're going to take care of you the best that we can. Not everybody's going to be a millionaire CEO, billionaire CEO of a corporation, right? A lot of people are going to have much tougher circumstances, but if you're among the least advantaged, the law is going to work in your favor. Quite simply, I'm going to argue that somebody who is 70 years or older is among the least advantaged with respect to what? Not wealth and income, but with respect to the prospects for a long, healthy life. Once you've reached 70 or 75 years, my mother is 76 years old and she's gone. She's gone. A lot of people are in good shape far beyond that, but my mother's got dementia at this point. You can't even carry on a conversation with her, So, which leads to some really funny moments, by the way, sometimes. I just roll with the punches with my mom. I bring over my little cat to the assisted living facility. We have a great time. But, Anyway, so my point would be that the difference principle actually supports my argument. Those 70 years and older are, in a very basic sense, among the least advantaged, not necessarily with respect to wealth and income, but with respect to what? The kind of prospects that a 20-year-old takes for granted. Years of healthy, active living in front of them. I understand that some people are kicking and kicking hard until they're past 100 years old. This is a right, not a duty, right? But I'm going to say that those who are past 70 years old, in a basic sense, are among the least advantaged, especially compared to very young adults, with respect to the prospects of a long, healthy, active life. And if you have responses to that, I'll be glad to hear that as well. The next one is getting down the... And these, by the way, every one of these arguments were brought up and dealt with in Glucksberg and Vacco. Granted, that was the constitutional context, but still, these are some of the leading arguments against the right to die. That's why I'm taking them up from a Rawlsian point of view. The next one, integrity of the medical profession. You can probably imagine that oftentimes they will trot out the Hippocratic Oath, right? That you should first never cause any harm and never voluntarily, any MDs here, never voluntarily kill somebody, right? You always want to move toward life under the Hippocratic Oath. Okay. Hippocrates lived in antiquity. There are 7 billion people on the planet right now. So it's not a slam dunk that the Hippocratic Oath should determine what public policy should be now. I certainly am sympathetic to doctors who do not want to participate in this, and certainly I can't, no proposal like this would require doctors against their will to go along with this. We're simply talking about doctors who would be willing to do it, right? So protecting the integrity of the medical profession, I think, also does not go too far, and certainly is not a basis for denying the right completely from a Rawlsian point of view. Finally, the slippery slope, right? The idea that, well, if we go this far and we go a little bit further and we allow that, we're right back in the soup. We have to allow it for everybody, right? So, for example, people say, give me some bumper sticker politics, right? A right to die will lead to a duty to die. No, it won't. Let me just shut that down right away. The 14th Amendment, which arguably would protect the right to die from a constitutional point of view, expressly provides, the 14th Amendment provides, no state shall deny any person life without due process of law. They can't just pass a law saying you now have a duty to die. So the right to die will not lead to the duty to die. The Constitution expressly says otherwise. So let me put that off. That's just a bumper sticker slogan sometimes that people will use. My second point related to that is that the law can and does draw lines all the time. We draw lines all the time based on age. You can't get a driver's license unless you're of a certain age. We draw lines, all kinds of lines. You know, you can only practice medicine if you've passed the medical boards. The law draws lines all the time. So all we would be talking about doing with this proposed ballot initiative that would extend the right to purchase and consume a lethal dose to those 70 years or older is drawing the line in a slightly different place. That doesn't mean that the whole thing is going to collapse. So again, I'm trying to forestall some of the most basic objections. And then finally, we come to an idea that Rawls develops at some length in a theory of justice, intergenerational justice. This guy thought broadly. And one of the things he develops in this is that Rawlsian decision makers are not just deciding for their generation. They're thinking about future generations who are vulnerable to our decisions today, right? And so we're not just thinking about the present generation, we're thinking about future generations. And when I bring that in, I'll bet a lot of you can already see where I'm going here, you know. Some people say, well, in an issue like this, money should never play any role. Really, why not? If I'm 70 years old, 75, 80, 85, whatever, and I decide, you know what, I've been very fortunate, I count my blessings, you know, I've got a lot of scars from living, but boy, I've had a good life. I don't want to spend the last couple of years in my life sucking up resources, you know. Maybe I've got a few resources, again, that I'd want to leave to some local charities and so forth. That would be an aspect of intergenerational justice. Choosing to die sooner rather than later in order to save resources for future generations who have a host of burdens on them. I mean, not just the environment that we're leaving to future generations, not just the federal debt that we're leaving to them. My students at San Francisco State pay $7,000 a year for public education. That's 35 times as much as I paid as an undergrad at Cal State in the 1970s. It's obscene. Under those circumstances, with everything else coming down on future generations, the least we can do is allow those of a certain age, if they want, partly based on economic reasons, but mostly based on liberty, to end their lives. And so that's the last part of my argument. Let me see if I have anything else to say. Conclusion. Yeah. Okay, enough of that. Okay, that's my argument, folks. So let me take any comments or questions that you have. And again, let me. Oh yeah. All right, let me keep your hands up. Let me start up here, and I'll get to as many of you as I can. I'll get to everybody if I can. Yes, sir. There's the.
I'm a medical doctor who practiced internal medicine for 50 years, and I was perhaps speak from this point of view a little bit, you know. When we go to emotional situations, right, and we know that emotions overrule rationality many times in a transient way, you know, then yes. We recover the rationality. If let's say a person wants to die after 70 and is completely healthy and has this emotional situation that pushes him to this decision, perhaps a time later he would be repentant of that, you know. There's an example even here in this community. A lady lost her husband, and very nice lady, intelligent. She was depressed for 1 year, you know, and was not very happy to keep living. And after 1 year, she found somebody who made her happy, and I doubt that at that time she would still singing, wanting to die.
Okay.
That's one point. No,
What is the point? I'm sorry. I mean, she...
No, that I'm not so convinced that a healthy person, 7 years or older, wants to die because the wife is terminally ill and dies. You know, that's one point. The other point I have to say, there's some technicality, you know, in prognosis. You mentioned that the condition is that the patient is declared incurable and will die in a term of 6 months, right? There are gross mistakes with prognosis. Prognosis is one of the most difficult points for doctors, you know.
Sure.
I know more than one case where the doctor died first and the patient was still alive years later, you know. So these are the 2 points I want to make. Otherwise, I agree with you completely. In my will, I put, I want to be killed, I want not to be kept alive if I became a burden for other persons,
right.
You know. I don't want to, exactly that. Okay.
Okay, good, thank you. Yeah, I guess my most basic comeback there is that you're right, that there are risks. It's possible that somebody who opts to end their life under these circumstances might turn things around a year further down the road. Here I'm actually falling back on the libertarians who say liberty has its risks. Liberty has its risks. Freedom has its risks. And in addition, even though that's a legitimate concern that some people might make the wrong decision, again, my question would be, why does that mean others can't have that right? Because one person or a few people might misuse it, according to our collective judgment. Why do we deny others the liberty? Because some people might misuse it, right? We don't ban alcohol because some people we know to a certainty are going to drink and drive, right? So that would be my response. Thank you. Okay, yeah.
I'll let you point.
Okay, yeah, yes, sir.
Okay, thank you. So I have 2 questions. First, I strongly support the right to die in the form as it was implemented in Oregon and Washington. And my first question is, what is the current experience in using these provisions, how they really work? And how they are considered successful? Can this become a model for other states, or maybe they found that they have to change something, improve something?
Are you asking about the Oregon and Washington
Right.
laws? Oh,
Right.
okay, okay.
Okay, and maybe then I'll ask my second question.
My understanding, I've read a little bit about that, and they actually suggested that especially in the 12 years or so, 12 or more years that the Oregon law has been in place, that there has not been a lot of abuse. There have not been lots of people who have exercised this option. There have been a few dozen over the years, but they have not found that, that it has led to a spike in people ending their lives. And the other thing we have to remember is that the current system right now does not always protect vulnerable parties as well as it might, right? So in law and public policy, it's never a choice between good and bad options, right? And maybe that's life generally. It's always a choice among bad options. And what's the least bad option? So, okay, thank you.
And my second question is regarding this 70 years old. Of course, the law can draw the lines.
Yes.
But this still sounds very arbitrary. Why?
I'm sorry, sounds what?
Very arbitrary. Why it is 70? Why it's not 69?
Oh.
Or why it's not 80?
Okay, good.
And to my opinion, it should be not an issue of age at all. It should be an issue of if a person has unbearable pain or suffering, then this can be a legitimate reason to die prematurely.
Good.
In any age.
Yeah, you know, as I said at the beginning, this is just one little corner of a vast range of issues, isn't it, right? And that's why I realized in approaching this that I need to zero in on one particular issue, right? Because that alone gives an awful lot. Look, if the 70-year-old, if we get to a point where some states start to allow 70-year-olds or older to do this, maybe there will be other developments of the law as well. So I don't deny that there are so many issues that this doesn't speak to. For example, what I'm talking about really has nothing to say for those who want to end their lives but who are mentally incompetent. I don't know what to do about those people. I don't have an answer. right? I'm talking about the narrow situation where somebody's 70 years or older, they are mentally competent, they can show that, or it appears that they're not being unduly coerced, and they know what their options are, right? So thank you for helping me clarify that. I am addressing such a narrow aspect of this, but I've been publishing for 15 years, 25 articles. I have learned that in order to complete an article, you've got to put limits on it, and you can't, like when PhD students start writing a dissertation, and they're trying to figure out a topic, it's usually like, I want to write on what is reality? No, if you're ever going to finish this thing, you need to put corners on it. You need to put edges on it, So, thank you. Yes, ma'am, what do you say?
I just have comments. I don't know that they're questions. I find it very interesting when you said Rehnquist. I know you saw me shiver. When you said Rehnquist.
Rehnquist, yes.
I shivered. and the duplicity, it seems to me, of the federal government it ceases to amaze me.
Sure, yeah.
The duplicity of the American government, state and federal, ceases to amaze me. So we're interested in due process, but only if you meet certain criteria. We're not interested in due process and a slow death like slavery, for instance. We don't have, it seems to me, the true interest of everybody in this country at stake. However, I have some questions. 70, I turned 70, so it seems young. And
isn't it funny how that works?
Isn't that amazing? And I'm a retired nurse, so I've seen a lot of people of many ages who are in their 90s, who are more alert than a lot of people I see walking on the street or driving.
You bet.
And my question is that who determines the mental status of the decision maker? Who determines what physician and what kind of physician and what religious take a physician has to be on a committee?
Okay.
A person of two. There are so many, and by the way, I agree with physician-assisted suicide all the way, but there are so many qualities of this that concern me, and I would hope that whatever government takes a position to enact this, that these are considered greatly.
Okay, very good. Thank you for that. So a number of questions in there. You mentioned the 70 years old, and this gentleman asked about it too, and I skipped it. 70 is arbitrary, but it's not. If we said 2 years old, if we said 120 years old, that would be arbitrary because it really wouldn't achieve the ends of justice. I think the reason that this movement, this is not me, this movement in the Netherlands said 70 years old. I don't know exactly why they chose 70, but it kind of makes sense. I think a lot of people have done the bulk of their active work life by 70. A lot of people are retired by 70, certainly not everybody. But, it had to be something between 20 and 120, And it seems to me 70 feels about right. If somebody wants to say, no, 71 would be better, okay, fine, The point is, at a certain point when most of us are of a certain age where, oftentimes if you're 70, you're feeling the aches. I'm 57 and I feel the aches and pains every day. That part where you wake up each day and oh my God, where did that come from? I'm there. All right, I've been there for a long time. The thing is, somebody who's 70 oftentimes will not yet be on their deathbed and may well want to look at that and say, again, liberty, freedom. I've had a good life. I've had some scars, but I can certainly count my blessings. And I do not want to spend the last years or months of my life in a hospital bed wasting away. That's what I want to avoid. And so I've had a good life. They're now giving me the legal right to do this. And so I think upon reflection, I'm going to do it. So that's all I can say. I wouldn't have a problem with it being 75. 80, I don't know. I just think that after a certain age, a certain level of maturity, it seems to me that this is when the law, in order to get as close to justice as possible, ought to, at a certain point, allow people the right to do this. And so, okay. The other thing is, sure, we have to make sure that the people that these folks have to talk to in order to get their lethal dose are reasonably qualified, right? Okay. So we'll take that up. I mean, government has to take up problems like this all the time. But the thing I don't think you're saying, and that I think I would push back on, would be that, well, since there's going to be some problems in administering this, therefore the liberty cannot be extended at all, right? Yeah, good. So you're right. We would have to pay attention to that. We'd have to make sure. I personally think that philosophers could have this conversation with people just as well. Maybe I'm a little biased. Or lawyers, because if nothing else, I used to be a lawyer. It's like, and again, not any old lawyer, right? But Lawyers, if they're competent, know how to listen, they know how to counsel, they know how to ask people questions and have a conversation. But not only lawyers. I think a lot of people besides MDs could do this, and so we'd have to look into that. But it's like Colorado and Washington are now enacting this new regime of medical marijuana, or recreational marijuana, you know? They didn't say, let's make sure we know all the details are going to be perfect and then enact it. No, they extended liberty first, and now they're working it out as they go along. We human beings just muddle along. That's what we do. We muddle along. So thank you for that.